So does that affect in any way your memory when you testify about the events that transpired between you and Detective Koepsell that afternoon?
Oh my God, what a good question.
Had alcohol, under the influence or impaired?
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what
are the legal grounds of your objection?
And I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters?
Judge, obviously we disagree.
Then where's the case that supports that?
I feel like it should be considered in your decision.
Anything else, Mr. Chair?
It's essentially the defendant stating that they want to make new case law.
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son.
Today's hearing went on a lot longer than I expected. Sarah Boone testified today, so there's 3 motions that we are addressing. Motion to suppress the 2-hour interrogation video. There was a protective order that the state filed, and then there was, the motion for the rights for hair, makeup, to get rid of the restraints for Sarah Boone. Now, before we get to the court stuff, let's just read the motions really quick. These motions were filed some as late as even today, like right before the court was about to start. But I'm going to read the motions really quick, and then we'll get to the court stuff. Now, if you guys want to fast forward to the court stuff, that's fine too. All right, so what do we have? Statement memorandum regarding defendant's statements to Deputy Kayla Rodriguez and Detectives Koepsell and Owen. If you guys remember, Detective Kayla Rodriguez, I believe, if I remember correctly, is the one with the body cam footage, the one that was really nice and tried to be as accommodating as she could to Sarah Boone. When Sarah Boone wanted her cigarettes, wanted her Dr. Pepper. She's like, no, you can't go in there. It's a crime scene. You can't be taking things in and out of there. And I think she was trying to get Sarah Boone some water, couldn't find any. She was trying to see if any other officers had cigarettes to give to Sarah Boone. But if I remember correctly, her name was Rodriguez. And then Detective Koepsell and Owen were the ones that did the interrogations. Now, let's see. What do we have here? Deputy Kayla Rodriguez, in response to a 911 call made by the defendant shortly before 1 p.m. on February 24, 2020, responded to the defendant's residence. Number 2, Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. 3, there are 3 recordings. One begins at approximately 1:08 p.m. and lasts 13 minutes and 32 seconds. The next starts approximately at 1:22 p.m. and lasts 4 minutes and 56 p.m. or 4 minutes 56 minutes. And then C, the final one starts at approximately 1:30 p.m. and lasts 5 p.m. 5 minutes 30 seconds. Is this right? I feel like these times are so short. Okay, so anyways, at no time was the defendant in anything that resembles custody for Miranda purposes. Ramirez v. State. The Ramirez case outlines the famous 4-factor test. A, the manner in which the police summoned the suspect for questioning. B, the purpose, place, and the manner for the interrogation. C, the extent to which the suspect is confronted with the evidence with his or her guilt. And then D, whether the suspect is informed that he or she is free to go to leave the place of the questioning. 5, while Deputy Rodriguez would not let the defendant enter the crime scene, no cigarettes, no soda, Dr. Pepper, whatever it was that she wanted besides Dr. Pepper. I don't like Dr. Pepper. Dr. Pepper is nasty. The defendant was not in custody. 6, the deputy was the first responder trying to give preliminary information about what might have happened. The defendant was spoken to on her porch and then sidewalk area just outside of her home. She was not confronted with any evidence because at that time there was nothing to confront her with. The defendant was informed she was not free to leave the area due to investigation, but the restraint of her freedom of the moon was never resembled a custodial arrest. Like, she was free to roam around, she was free to, drink from the hose, but she just couldn't leave that area because obviously, there was a dead body that was found in a suitcase in her apartment or in their apartment. Number 7, just under 4 hours later, she was interviewed by Detective Koepsell and Owen inside an unmarked car on scene. Although under both Ramirez and Rinkin, this is not custody for purpose of Miranda, she was given her Miranda warnings. 8, for the reasons outlined in the state's response to the defendant's motion to suppress statements at Orange County Sheriff's Office, the Miranda warnings were not defective and her waiver Miranda rights were voluntary and her statements was voluntary. Hi, Kay. 9, any motion to suppress on these statements should not be granted. filed by Mr. William Robert J. Yeah, so these are minutes. Oh, are these? Oh, I see. These are just the interactions with Sarah Boone. Okay, I was just thinking the body cam just being on. But they're just talking about any interactions that she had with Sarah Boone, I guess. Okay. Amended notice of taking deposition. So they're doing the deposition of Dr. Michael Brannon. Dr. Michael Brannon was initially supposed to be a forensic psychologist expert, but then I guess he is now labeled as the clinical psychologist, because the forensic psychologist is going to be Dr. Julie Harper. State's request for a protective order. Okay, so this one is kind of a little bit snarky. Hannibal Crossing. Hi, how's it going? I don't think I've ever been so excited for a trial to start. I feel like I'm not ready. I don't know. It doesn't feel real that this trial is going to start next week. It doesn't feel real at all. So this is the state's request for a protective order. 1. The defendant in her third amended witness list has listed 4 people as witnesses. A. Custodian of Records, Orange County Office of State Attorney. B. Domestic Violence Supervisor for the Office of State Attorney, 9th Judicial Circuit, Orange County. C. Victim Advocate Supervisor for the Office of the State Attorney. D. Misdemeanor Supervisor for the Office of the State Attorney. 2. The state requests a protective order under Florida Rule Criminals Procedure because anything these witnesses can say about the defendant and the decedent will be protected by the work product privilege. 13. If the defendant wants a public records from the state attorney's office, she should do what everyone else has to do. File public records requests. Ooh, but I don't know if that's going to come in through in time because, trial starting next week. 4. Subjecting prosecutors and their staff to this type of discovery for the investigation will require disclosure of work product and seriously impede criminal prosecutions. Egan v. Demanio. 5. We believe the trial court was right the first time in denying the pretrial defense efforts to subpoena the 2 state attorneys and inquire into oral communication, sworn or otherwise, between them and a state witness. The oral and unrecorded statements of witnesses of a state attorney are privileged as a work product and not subject to discovery. 6. Opinion work product involves a lawyer's impressions, conclusions, opinion, and theories of her client's case. Opinion work product is an absolute or nearly absolute privilege. Horning Keating v. State. 7. Fact work product concerns what the attorney did and what she learned in her role as the attorney. As the name suggests, fact work product is factual information which pertains to the client's case prepared or gathered in connection therewith. Citing Rabin. 8. The fact work product is discoverable only if the parties seeking this work product show the court 1. The need of the fact work product to prepare a party's case. A party's case. And 2, that without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing. I mean, something just tells me that James Owens is just really short on time. And, he probably would try to get his information himself. But the reason why he's reaching out to the state to give information, to them is because they're just short on time. He's like, hey, you know what, state? Just make it easier for me. Just give me the information that I need. And the state's like, no. That's not how things work. I mean, like I said, we have another week before the trial starts, okay? 9. The state is at a loss for what non-privileged testimony any of the people listed above could provide in this case. Number 10. Therefore, the state is requesting the court to enter protective order to prevent any employee of the state attorney's office from being a witness in this case. So let's see what the judge says. I also want to know what the judge is going to say about the motion to suppress. Because like I said in the beginning of the stream, I was pretty clear that the motion to suppress, that's going to be filed by the defense. It has to be filed by Friday night, not end of business day, but end of day. And then we saw the motion to suppress was filed on Monday instead. So I just wonder if the judge or anyone's going to have any issues with that, or, maybe there were some things with, I don't know, maybe Mr. Owens couldn't do it because, maybe the hurricane also affected him as well. Amended motion to suppress defendant's statements at Orange County Sheriff's Office, because sometimes when you do the makeup thing and either someone doesn't know how to put makeup on you or you try to put makeup on yourself, you might be looking like Lori Vallow the clown, okay? Because Lori Vallow, I don't know where she got her prison makeup, but she'd be showing up to some hearings, man, with some bright red cheeks, with some eyeshadow, with the lippy and stuff, and she just looks horrible. I don't know. I know she's trying her best to look good, but it just sometimes doesn't look very, very nice. Okay, or I guess if Sarah Boone gets really sweaty, maybe some powder foundation. That could help a lot if you get really sweaty, but I don't know if she does or not. Shiro's a lawyer. Corky is just a legal aid. Shiro is he is sleeping right now. Okay, this guy he's always on vacation. All right, he's still on PTO right now. So I'm just carrying. I'm doing all the work right now. All right, so amended motion to suppress defendant's statements at Orange County Sheriff's Office. This was filed by amended motion. Yeah, this is filed by Mr. Owens. Number 1, defendant Sarah Boone is charged second-degree murder. On or about 24th of February 2020, defendant called 911 in response to finding her boyfriend George Torres deceased. 3, Deputy Kayla Rodriguez at the Orange County Sheriff's Office arrived on the scene with her body cam activated. Upon arrival, Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her supervisors and secured the scene. 4, sometime later, homicide investigators Chelsea Connolly, aka Chelsea Koepsell, and Scott Lowen arrived. These 2 investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at the Orange County Sheriff's Office the next day. 5, defendant was ordered to remain on the scene while Orange County Sheriff's Office conducted their investigation. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. Number 6, at some point, the defendant was told to get into an unmarked vehicle with Detective Koepsell and Detective Lowen. Once inside, Detective Koepsell recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. The defendant was advised that this recorded interrogation was routine protocol and official procedure for any death investigation. I mean, honestly, we listened to this audio recording in the car about a couple days ago. I think there should be a standalone video posted on my YouTube channel. Did I forget? No, I don't think I forgot. I think the video is up there. Oh gosh, I hope I didn't forget. I actually forgot to post the Hannah Reid hearing that we watch. I completely forgot to post a video of that on my YouTube channel, but the live stream is up. Y'all can watch that. So we listened to the audio recording, and you know what? When she read the Miranda rights, it was clear and cut to me. Okay, and I think at the end she's like, "Do you understand what I'm saying?" And she's like, "Yeah." Sarah Boone responded, "Yeah." So that's what I remembered. Number 7, during the investigation, Detective Koepsell asked to see the defendant's phone. Defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and instructed the defendant to unlock it. Defendant complied with the demands of the lead investigator. 8, after Detective Koepsell had the defendant's phone for a period of time, she came back and told the defendant that she was taking her phone. Detective Koepsell asked the defendant to sign a form releasing it to the Orange County Sheriff's Office for further investigation. The defendant acquiesced to the authority and signed the form. Remember, they were trying to... Was it what Sarah Boone was pro se? I think she was trying to say that, like, oh, you know, they seized my phone without my permission or something like that, or they did it in an unlawful way. Number 9, the defendant was told that one of the detectives returned her phone to the defendant at her apartment in Winter Park the following afternoon. 10, later on that evening, the defendant moved to her ex-husband's home. Oh, God, poor Brian Boone. For the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Koepsell on her cell phone to express her concern that Detective Koepsell was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed they were trying to trick her and being sneaky about something. 11. The detective assured the defendant that they were not trying to trick or implicate her. Oh, I wonder if this recorded. I wonder if this phone call is recorded. It has to be, right? Do you think they're going to play it in trial? But that following day, the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. The detective explained that the reason for the change in plans was because she was pregnant, not feeling well. 12, the next day, February 25th, 2020, the defendant arrived at the Orange County Sheriff's Office to retrieve her phone and had questions about this tragic event. Yep, she showed up. She had, I think, like a little notepad with her questions she was going to ask. Upon information believed, a judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's apartment. 13, while still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into the interrogation room. Detective Lowen wore his firearm in his waist during the entire event. A custodial interrogation ensued. Immediately after the interrogation, the defendant was formally arrested and charged with the offense above. So there's a 2-hour interrogation that was recorded. We're going to watch it today. The initial dialogue between Detective Koepsell and defendant Sarah Boone. Detective, I'm going to have you sit in the green chair. Detective, appreciate you coming in. Sarah Boone, yes, ma'am, I want to ask about these whenever you have a moment, referring to her written notes with question. Detective, sure. Detective, so obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about it. Detective, and we're not done talking about the incident. Detective, we just have to do it. Sarah Boone, just like what we did yesterday. Sarah Boone, normal protocol. Detective, just like what we did yesterday. Detective, remember, I read you your rights. Detective, yeah, it's the exact same thing, but since I'm asking you the follow-up question, I need to read them to you, okay? Detective, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during the questioning without charge. If you can't afford an attorney and want one can be provided with you, for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone, no. Detective, and do you understand what I just read to you? Sarah Boone, yes. Detective, perfect. Okay. Detective. So this morning we went to the autopsy and we were informed of the injuries he had by the doctor. Defendant where? Detective, so he's got a scratch marks on his back. 16. The interrogation continued for approximately 2 hours, and at the end, while still in the interrogation room, the defendant was placed in handcuffs and was arrested. Is this the amended version? Because is this the amended version? I don't think this is the amended version, is there? Because, when we look at Mr. J, the assistant state attorney's motions and responses to motions, there's a bunch of case law backing it up. And I'm like, ain't there supposed to be some case law in here just so the judge can kind of, know what angle you're coming at? 16, the interrogation continued for 2 hours. Oh, I read that already. 17, hey, beautiful, messy ball. Hello, hello. How's it going today? Sarah has more snottiness in the voice. I haven't practiced my Sarah Boone voice yet. I could do the Elaine one, because the Elaine's is like kind of fun to do. The Sarah Boone one is like really like meek and like a little bit of a high pitch. Lady, hi Go Lucky. How are you guys all doing today? Hello, hello. 17, detective read the defendant her Miranda rights directly from the printed card. Detective omitted the final question printed on the standardized Miranda card at the Orange County Sheriff's Office. The detective omitted the same Miranda rights question that she omitted the day before. She omitted the final rights question is, having these rights in mind, do you wish to talk to us now? 20, the defense has yet to receive a true and accurate copy of the Miranda rights card from the Orange County Sheriff's Office. 21, upon information belief, it should look like something like this. 22, based on all the circumstances surrounding the interrogation, the defendant's statements was coerced and not freely and voluntary given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. Mr. Owens. Okay, this is just like an amended witness list. Mr. Owens. Oh, okay. Wait, do we got case law stuff? Hey, they were listening to us. All right, well, while we wait for okay, so Judge Krenik is here. Hi, Judge. Well, he's not here, but his desk is here. He posted some case law from the Miranda. Let's read them really quick before they talk about it in the hearing then. Procedural posture. September 30th, defendant filed a amended motion to suppress attachment. 4, where a defendant is subjected to custodial interrogation, he must be administered the proper procedural safeguards commonly known as Miranda warnings. See Miranda v. Arizona. In the seminal Miranda v. Arizona decision, the Supreme Court enunciated this bright-line rule to guard against compulsion, the coercive nature and atmosphere associated with the interrogation, to assure the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. I mean, most of the Miranda was read, to me, it seems pretty clear. 5, while the defendant may waive effectual of these rights, such waiver must be made voluntarily, knowingly, and intelligently. That's what it seemed like. The court must make a case-by-case determination based on the totality of the circumstances to whether the waiver was constitutionally sufficient. Are they here yet? Nope, not yet. 6, therefore, the Miranda warning and waiver demonstrated by the prosecution. No evidence obtained as a result of interrogation can be used against the defendant. All right. 1, defendant was in custody for purpose of Miranda. 7, custody encompasses not only the formal arrest, but any restraint on freedom of movement of the degree associated with the formal arrest. See Trailer v. State. A person is in custody if a reasonable person placed in the same position will believe that his or her freedom of action was curtailed to a degree associated with the actual arrest. 8, it is uncontroverted. Defendant was in custody for the purpose of Miranda. On February 25th, 2020, defendant arrived at Orange County Sheriff's Office where she was directed to an enclosed interrogation room. Therein, she was surrounded by 2 detectives, Koepsell and Owen. Furthermore, Owen's firearm was visible in the waist throughout the interrogation. Therefore, it is reasonable for the defendant to believe that she was not free to leave at that time. No one here yet. I'm going to keep checking. Okay. But I feel like for his case law, it needs to be super specific to what he's claiming, right? Saying that like, oh, well, you didn't read the Miranda cards to the T. I feel like you have to get as specific as you can. Maybe we'll get there. 2, defendant was subject to interrogation for the purposes of Miranda. 9, interrogation is any questions or actions by the state agent that is likely to elicit an incriminating response. 10. In this instant matter, the defendant was directed to an interrogation room where she was subject to investigative questionings for 2 hours. It is undisputed that the line of questioning exhibited by both detectives was likely to elicit incriminating responses. Therefore, this court should find the defendant was subject to interrogation for the purposes of Miranda. You know how there's that picture of Sarah Boone and it's her mugshot and she's like slightly smiling? Was that when they arrested her? Was that when they took that mugshot? Because I don't know. I was looking on Google the other day. I was like looking for like Sarah Boone pictures and stuff for like thumbnail, and I was like, I don't know. I guess it never really caught onto my mind that she was like kind of smiling a little bit in this. It looked like a mugshot, but I don't know if it was the mugshot when they arrested her the first time, or maybe they just picked, like maybe they did the Window Adelson thing where it's like, hey, you know, like, can you stand up, Wendy, and like let us take an awkward picture of you really quick just so we have it on file. Oh, wait, people are coming in. Oh, good. Mr. Owens is there in person. Yay! He's there in person. No tech issue. Lori knows that he has about 5% chance of winning this suppression. All right, 5% chance. What helps in his 5% chance? Did he mention that? When did he file this? I don't know. Like, this was uploaded a couple minutes ago. Should I continue reading? Well, I mean, they're walking back and forth. Okay, I'll read like a paragraph and then go back and forth. The state has not proven that waiver has made knowingly, voluntarily, and intelligently based on the totality of the circumstances. 11. A court must determine based on the totality of the circumstance where a voluntary and intelligent waiver of Miranda rights has been made. In making this determination, the factors considered by a court included the background, experience, and conduct of the accused. North Carolina v. Butler. 12. First, the detective minimized and downplayed the significance of the Miranda rights before interrogating the defendant. See Ross v. State. Holding where police minimize and downplay the significance of the warnings that the very purpose of Miranda is undermined. In this instant matter, the purpose of Miranda was undermined as follow. Detective, so obviously he received his autopsy. Detective, so I'm going to read your rights again because we have to talk about it. Detective, we're not done talking about the incident. Detective, we just have to do it. There, boo, just like we did yesterday. Normal protocol. Normal protocol, right? Detective, just like we did yesterday. Remember, I read you your rights. Yeah, it's the exact same thing, but since I'm asking you follow-up question, I need to read them. I don't know. It doesn't really seem like it's downplaying it to me. Maybe sort of sounds like you're downplaying it when you're saying like, let's see, we just have to do it. Does that sound like we're downplaying it? It sounds like, hey, this is something that's important. We have to do it, and I have to do it again, just like I did yesterday. I don't know. That's how I interpret it. Number 13. The aforementioned line of communication highlights. Oh, that's right. We could see when. Here we go. 10 to 2:35 p.m. So about, 35 minutes before the 3 p.m. pretrial. Where was I? I was over here. The aforementioned line of communication highlights a coercive nature detective. Every time I say detective, I just want to say defective. I don't know if it's because I don't have my glasses on. The aforementioned line of communication highlights the coercive nature Detective koepsell's action. In addition, it is apparent that the defendant believed the time that she had to speak with detectives and that the warnings were just a form of protocol. I don't know, man. I think Sarah Boone went in there thinking that she can wiggle her way through out of this. I really think she did. Second, defendant was not improperly informed of her rights to make a voluntary and intelligent waiver of such. Detective koepsell failed to ask the defendant, having these rights in mind, do you wish to talk to us now? Oh, gosh. I just feel like, I don't know. It just doesn't feel like enough to me. Yes, he, provided case law about, how Miranda has to be read, how the person that it is being read to, they have to understand, they have to be they have to intelligently, I hate that word, waive it, be set of mind. I mean, okay, yeah, I see the case law for that, but then I feel like there needs to be a little more specificity. Like, oh, here's a case law where the detective didn't read until the very end of the, the standard card, and because of that, they had this interrogation thrown on it or something. 15. 15. Finally, based on the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. I don't know. It just doesn't really feel very strong to me. But, we'll see what the judge says. Judge is smarter than us. Let's see what he says. I now certify I electronically filed the proceeding with the clerks of clerks using the e-portal system, which I understand will send a notice of electronic filing. Oh my God, I can't see this. To the office of the state attorney on this 30th day of September. I mean, it seems like he did it on the 30th. The defendant's case law submitted on September 30th regarding motion to suppress filed on September 24, 2024. Its response. Oh man, we love these last minute stuff. But I mean, the state had to, right? Okay, the defendant filed a motion to suppress statement on September 24, 2024 without citing any case law to support her decision. On September 26, the defendant submitted cases to the court regarding her motion. So 2 days afterwards, the 26th was what day again? 26 was last Thursday. Okay. On September 30th, the defendant filed additional case law with the court. These cases appear to involve issues outside the four corners of her motion to suppress statements. The state objects to any additional claims being raised at the hearing that were not specifically pled in defense motion. State v. Christmas and Vera v. State in the first of these cases. In that case, while not actually having a video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, alleging that they did. The detectives in this case never said they had evidence they did not. And the defendant declined viewing the video she made while the decedent was in the suitcase, asking to be let out. Wait, hold on. In that case, while not actually having any video surveillance of the defendant committing the crime, the police seized the truck 3 times, alleging that they did. Detectives in this case never said they had evidence they did not. And the defendant declined viewing the videos she made. In that case, while not actually having video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, alleging that they did. Detectives in his case never said they had evidence they did not have. The defendant declined viewing the videos she made while the decedent was in the suitcase, asking to be let out. There was never any threat of the police taking any action or inaction based on what upon she told them. The case is inopposite. The defendant next submitted Johnson v. State, while law enforcement specifically asked the defendant if at some point somebody gets enough when they have to do something to defend themselves. The defendant stated, "I would just flee, and I don't know if you, ... There was never any suggestion, as there was in Johnson, that a self-defense claim was her only way out, much less that she would not go to jail if she claimed self-defense. In fact, the defendant repeatedly and adamantly denied there was any problems that night with Sarah Boone, and denied that she did it intentionally. 5. While the defendant was questioned about how much she had to drink the night of the homicide, she said that she had a reason she did not remember filming the decedent, asking to be let out of the suitcase because of her drinking alcohol. There was never any suggestion by law enforcement that involuntary intoxication was a defense or that things would be better if she had admitted that she was intoxicated. In fact, the defendant continued to insist that she was not intoxicated despite having a blacked out and not remembering filming what she said to the decedent while he begged her to be let out of the suitcase. 7. Therefore, these arguments, while outside of the 4 corners of the motion to suppress, would not be allowed for the court to grant her motion to suppress either. Okay, back. Now into the court stuff. The first motion they're going to address is the motion to suppress. There is an issue that the defense has with the 2-hour interrogation video. They are mainly blaming Detective Koepsell for not reading the last question on the Miranda card. So now in the pretrial hearing, we have Detective Koepsell who's going to go up there and testify. It's a little bit rough. The audio's a little bit rough, but we'll get clippets of it, and I'm doing my best to fix this. The defense is accusing law enforcement of deception, tricking Sarah Boone to come in for the interrogation, being very deceptive, not being forthcoming, and then getting Sarah Boone to essentially talk about the crime when she didn't understand what her rights were.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Koepsell.
Koepsell.
H-E-L.
Oh, I knew I've been pronouncing it wrong the entire time. I'm sorry. Mr. J is the one who's conducting the direct examination of Detective Koepsell. She talks about how she arrives at the scene with her partner, Detective Owen, and she was briefed by the department about what possibly went down with George Torres and maybe even with Sarah Boone. So she walks the crime scene, with the department. She gets to talk to Sarah Boone a little bit here and there. And then she was also able to talk to Brian Boone as well. Try to get as much information as she can out of him. She was the one who drafted and was able to get the search warrant executed. There was also a crime scene. I think it was like someone who specializes in cell phone, like a digital forensic detective, I guess, who was able to get into Sarah Boone's phone and extract data out of it. Now, before they found out what was on Sarah Boone's phone, Detective Koepsell with her partner, Detective Owen, got Sarah Boone into an unmarked vehicle, and that's where we heard the audio interrogation where she read the Miranda rights. And again, the defense, James Owens, has issues with how the Miranda rights were read. They said it wasn't read fully according to Orange County Sheriff's Office Department policy procedures during that time. But here's the thing that Mr. J was able to get out of the witness that's testifying in the stand. And this part is important because Sarah Boone, well, remember, she testifies and she's going to give a different version of events.
Well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs, and so I don't think I really touched it until after I had talked to her about going through it.
All right.
And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but yeah.
Now we got Mr. James Owens who's doing the cross-examination, and they're going to go through the process again. However, Mr. Owens wants to make it clear to everyone else, when was Sarah Boone considered a suspect? And then also bringing up the cell phone thing again.
Any cross-examination?
All right, James Owens, come on up.
Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone?
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form, Sarah, give me the password to your phone?
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, your testimony is you asked her for a password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator?
Yes.
And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is, at some point, you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This is 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But
Okay.
I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
Is he trying to say that the reason why Sarah Boone claims that Detective Koepsell said it was routine protocol because they wanted to minimize that Sarah was going to be Mirandized? Because that was part of his motion, I guess. Like, oh, they're trying to minimize, Sarah Boone being Mirandized. Maybe that's where he's going with all this? Now, we're going to get back and forth between Mr. James Owens and the judge, and this might be a little bit of a deja vu for some of you guys, maybe from a different hearing.
All right. Now, once inside the squad car, you were there with the other detective, Detective Owen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So,
Yeah, that's where I was like, I felt like the case laws weren't specific. The one that he was providing to the judge, Mr. James Owens. I was like, I feel like it needs to be more specific to what he's trying to claim. All right.
how is it relevant for the card that is in the motion upon information and belief? This is what it says. So how is it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now.
This is the exact same thing that happened a couple hearings ago where the judge and Mr. Owens were going in circles about this, and it wasn't going anywhere.
The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th. This interrogation ties into that one. She
Wait,
used
I thought we're focusing on the 24th right now.
the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States, and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names.
You see that whip around? Mr. Owens was so fast to whip around. He took off his glasses. Playback.
To the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring to surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's fine.
Okay.
You may proceed.
Oh, gosh. Now we get Detective Capsule's perspective as to why she did not read number 9. Why was number 9 not read?
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Yes.
Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is
Correct.
Wait, I thought we were already done with this. Objection overruled. Wait, what?
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card, but continue.
I'm sorry?
It's not on my Miranda card that I read from. But you can continue.
She said it's not on my something card, something, something. I couldn't hear.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card.
Oh, she's saying number 9 was not on her card. That's why she didn't read it.
We have multiple Miranda cards at the sheriff's office, but yes, that is in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
Okay, that was a long moment of silence, but now back to the cell phone.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back?
No.
You did not tell her that?
No. I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
All right, tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
Because on his motion, he said that Sarah Boone borrowed Brian Boone's phone, and then I guess, was it in his motion, right? Not the state's motion. I think it was in his motion. And then used his phone to call the detective. And the detective was like, oh, I'm pregnant, tired. Like, can you come to me and meet me here instead to get your phone?
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines, yeah.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time?
No.
Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence?
Standing next to me.
Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
Okay. At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
Is that the answer?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all that next day, I think you had her coming in the afternoon.
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it, though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or was there anybody else there?
I don't recall if Detective Lowen was with me or not, but yes, of course, there's doctors there.
Okay.
And it feels like at this point, maybe the judge is also starting to lose a little patience because he's not sure what Mr. Owen is trying to get at. Maybe even the state as well.
And so, in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect, they had probable
What does
cause.
that have to do with any of the 3 issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response.
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first. The objection is sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not going to be free to leave.
Excuse me?
She was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway.
Correct.
And that was based on your investigation that you had the night before at the scene. And it was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection, relevance. As to what the probable cause basis.
Sustained.
Yeah, I'm a little confused where we're going with this.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you. Before you
Does she have her arms crossed?
began your interrogation of Sarah Boone.
I had all what information?
All the information that I just related to you. Before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes, I do want to show her the videos.
And you agree, in your opinion, the 2 videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time?
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, irrelevant.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall?
Now, like, would she really be reading his motion? Hi, Andrea. How are you doing today?
You saying to her, I'm going to have you sit in the green chair?
Objection, best evidence is the recording.
He's right.
Okay,
Objection sustained.
okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection, best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection, improper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, improper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask for question number 9.
Okay.
This is the waivers and affidavits.
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or not?
Yes.
And you did not read her Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, no.
Okay, you you would agree that there's 9 questions on that one? You know?
Yes.
So there was a little bit of a jab from Detective Koepsell to James Owens. The state, they're going to object, and same back and forth between James Owens and the judge in regards to Miranda rights and the case law.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously,
Yeah, obviously.
Miranda rights.
response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including...
And the judge has asked this many times already, not in just today's hearing, but in the previous hearing as well.
Anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you
Today's going to be a long hearing. We're only talking about one of the motions so far. We still have 2 other motions after this.
agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement. And whether that
The judge is going to be like, okay, where's the case law? Where's the case law? Where's the case law? Where's the case law?
waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it
All right, y'all heard that. Sarah Boone's going to testify. We heard it from Mr. Owens.
was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr.
Feel
Chair?
like.
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Sarah Boone is now going to testify, and I'm not really going to cut a lot out because I think you guys should listen to the entirety of the testimony, especially the cross-examination.
Judge, I'd like to call Sarah Boone. Ma'am, would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
She said she was worried about her dog. She was worried about her son. Did y'all hear her talk about her dogs, her son at all in the body cam video? No, it was like, oh my God, I need my cigarettes. Oh my God, I'm thirsty. Oh my God, I need my Dr. Pepper. I don't remember hearing her saying anything about her dogs, anything about her son. Just saying.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation in the
There's no jury here. There's no jury here. We don't need this. Just go straight to the point. Let's go.
case law cited by the state requires
Is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions, so it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained, and it's stricken.
So you didn't prep her?
All right. Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car?
Now, remember what Detective Koepsell said about Sarah Boone's phone. This is what Sarah Boone's version of the story was. Detective Koepsell said that, she was able to get the waiver sign, and that's when the phone was unlocked and the digital phone person came and, I guess, extracted data. Sarah Boone is trying to say, no, I didn't sign anything. They actually made me unlock the phone before there was a waiver signed.
Was the phone issued before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that koepsell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Objection calls for cease fire.
Sustained.
I believe.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Koepsell.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Koepsell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
All right. Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right.
Did you understand your Miranda rights?
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you...
I mean, maybe she didn't have any friends or anything, but if you were terrified that George's family was going to come after you, would you really bring the danger to your son, though? Like, would you want to stay in the same place where your son was staying? Because couldn't they technically just, like, look on the white pages to see, Brian Boone, Sarah Boone, last associated address or something like that? I don't know. Maybe she couldn't afford a hotel or something, or maybe she didn't have any friends to stay with. Maybe she really thought that George's family didn't know where Brian Boone and her son lived, but, I mean, I felt like you could just look that up.
You attempt to contact Detective Koepsell.
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Koepsell told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Koepsell's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
Objection sustained.
There's no pending question at this time.
Okay. You were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Objection. Irrelevant what her statement is.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
I didn't call for a yes or no. She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective koepsell was pregnant and not feeling well?
Correct.
I mean, we're getting a preview of how she's going to testify in front of the jury. Yes, I was confused. I was really worried. I didn't know what was going on. Like the really soft voice. But Sarah, we've seen the letters. We've heard you in the body cam. We saw you in the interrogation. We saw how you are. This is like, I don't know. This is kind of like classic, like Amber Heard, like, yes, like, I was Johnny and then blah, blah, blah. Like, when they're trying to portray that, like, there's like a soft, quiet, like, oh, harmless woman. I don't know, man. It's hard. It's hard because, we read the letters and all that stuff.
So the next afternoon, did you drive to the sheriff's department? Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking
Like when Jodi Arias is testifying.
who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
Huh?
I believe he was wearing a red shirt along with his firearm and black pants
Oh, maybe
His
the
firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator, where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room?
Correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes.
correct? And you've seen the motion.
Are we still in the first motion? Yes, we are. We have 3 other motions to go through. And then also, why would the cop not have his gun? In Owens' motion, he was arguing that, the officers had their firearms. Sarah Boone felt like she couldn't leave the interrogation room. I think that's why they're trying to highlight, what was the officer wearing? Oh, he had a firearm on? Dang!
Motion, where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
She also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with him?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said, normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read, having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did.
Oh, is it going to be like, oh, had she read the last question, number 9, would you have agreed to not speak to her? Or would you have not agreed to speak to her?
Correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant, it's just in custody.
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well,
Well,
under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to
she was
whether or
being
not-
questioned- let me finish. She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under remedial
the judge interrupts and then he wants to finish, but then when he's finishing, he doesn't really add any more value to his argument. And then the judge is like, has to listen to the entirety of his argument. And the judge just goes back to, okay, well, what does it have to do with anything? How is that relevant? I feel like we need to give the judge a shirt. How is that relevant?
as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Oh, gosh.
Did you understand you were not going to get your phone back until you answered their questions?
Objection, relevant.
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Objection, relevant.
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us.
Yes.
Rule.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Woo! Okay, cross with the state.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Correct.
And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Koepsell that afternoon?
Oh my God, what a good question. Oh my goodness. What a golden question.
Home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Koepsell that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Koepsell that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
Ooh, this is how you know she got stuck. She's like, ah, shit. Because it's like, oh, can you ask the question again? Oh, let me ask the question out loud to myself real quick so I can stall and ask for more time and see what I can come up with.
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent, and I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
She understands the question. She just realized that she kind of trapped herself in it. Oh my goodness.
I was hungover. I was still, I believe, intoxicated to a degree.
There was something else I wanted to say. Shit, I forgot. It's okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I withdraw it.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge,
Regarding the
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Koepsell's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witness today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The 2 prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different, and obviously if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the
Someone said earlier, I don't think Sarah Boone knows is 22 years minimum. I don't know where it is. I just lost it, but I'm sure she does, because when Mr. Owens was trying to go back and forth between the state and Sarah Boone in regards to like potential plea deal, I'm sure they gave her the facts. Like, hey, you know, you're facing this. If you're prosecuted or if you're convicted, this is what happens to you. This is the minimum. This is the max you're facing. So I'm sure she's got to know. I'm sure she's got to know that. Yeah, and don't forget, feel free to like the stream if you guys are enjoying.
objection based on how the question was asked. I'll allow you to revisit it based on how you did.
Her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details.
So Sarah Boone today was scheduled to have a I think it was like okay, so Dr. Julie Harper was the forensic psychologist that evaluated Sarah Boone. That was by the defense. The state also gets to hire their own expert to evaluate Sarah Boone as well, and that actually happened today. So I think that's what they're referring to.
Statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we can proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
Okay, so we're wrapping up final arguments. We've already heard a lot of these arguments, so I'm just going to get to the point of it.
So you got Detective Koepsell on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened.
Would it be different if the statement was reversed? If law enforcement instead said, you have to do this, you have to talk to us, would that make his argument stronger?
But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
Oh, true. We have to take the context of it. We have to reference the reading the rights. Yes. Yes, I do remember that, actually. That was the context, wasn't it?
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses.
Yeah, this is what happens when you run out of steam in your argument. You just keep repeating yourself.
Coupled with the fact she doesn't have the ninth question.
Mr.
The United
J.
States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read.
Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Okay, we only got 2 more motions to go. The motion for the hair and makeup and to get rid of the restraints.
And just a clarification, but she's here today and she's in handcuffs, so she has difficulty writing.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee, but she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And the people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
That's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom
You're never going to
first.
see her walking out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny, and she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance
What about the shouting match you guys had?
of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Now, in regards to clothing for Sarah Boone, the judge said that you can bring the clothing to the jail, and then the jail will transport the clothing and Sarah Boone together, where they'll make sure that there's nothing weird in the clothing, and she'll get dressed, and she gets to wear, what she wants to wear. They probably need to have someone to come in with Mr. James Owens to take Sarah Boone's measurements to make sure everything fits properly, so she doesn't have to staple her clothes again and get in trouble for it. And then the next thing is about hair and makeup. Okay, so this hair and makeup argument is kind of interesting. I'll let you guys hear it from Mr. James Owens' mouth yourself.
And the Estelle case that you cited to, spoke to being dressed out in a prison garb. It doesn't really address
Makeup,
a prison guard in
hair.
shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even.
I don't know. Mr. Owens says I think a lot, and judge is like, just give me the case law. Yeah, but I think. Oy, oy, oy.
Been purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the 2 paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can They can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Holy shit, what is this, a wedding? Do you guys remember, have you guys ever attended a wedding and then the bride asks you, oh, hey, I see that you're pretty decent with makeup. Can you put makeup on all the other bridesmaids?
Can she be allowed, can the two females on the team, can they be allowed to apply some type of makeup to Miss Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but...
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court.
You might be halfway done.
And I intend on starting at 9 o'clock every morning.
You might have one
So
more
I'll
guy
have
later.
pleas every morning and other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can have someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed.
Yeah, that's risky, man. Because I think it's risky because if you're sitting there and your makeup looks bad, you're better off just going clean face, bare face. You don't want to be sitting there with like super red cheeks, or like if the eyeliner is like screwed up, if you're trying to draw the eyebrows in, if they look all jacked up or too dark. Like, I think it's just best to just leave it alone. Or the foundation is off and you look too cakey, like, I don't know about that.
I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yes.
Okay, so what is he saying?
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back.
Oh, how do you take off the makeup, I guess? You need to get a makeup remover?
To the Orange County Jail. They don't know if it's contraband. They don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay.
And the worst is if it's like waterproof makeup and she can't get it off, and then like she's gonna, I don't know, and it's still gonna be like maybe on clumps of it next day possibly if it's like mascara. I think she looks fine. She doesn't need makeup. She looks fine.
Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow.
And now lastly to the last motion that the state filed in regards to the protective order. It seems like James Owens filed a witness list that had the names of prosecutors, names of people that work for the state. Like there was one that was a victim advocate, a couple of those people as well. And the state is trying to say that their work product is protected. Mr. James Owens, if he wants to get information about them, he needs to maybe file a public records request. Now, why does Mr. Owens want this? It's because Mr. Owens says that George was arrested 3 to 4 times. And, they were dropped 3 times. And he wants to make a point of not why it was dropped, but who was in the decision of it being dropped. And that's going to go towards his battered spouse defense. So y'all can listen to this part too. I recommend you listen.
Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and super.
They basically just said that like when she comes back to the jail with the makeup on, that could be considered contraband, like the makeup on her face. Like they don't know what the ingredient is made out of and all that stuff. I don't know if you can make a bomb out of it. I don't know. They just want to be on the safe side,
Supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for. I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
Is he prepared?
That was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the
This is the protective order.
Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome
Yes.
in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from any is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state.
2021? The Aspire records and the Advent Health records.
And that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents, it is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is
Say what now?
going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it,
Okay.
as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
I could have sworn he said. Okay.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, State, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining
Exactly.
that.
Is that taking place here, or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did
I don't know. He just did a huge sigh there. I wonder if he's like, you knew this. I don't know. There was maybe I'm just overreading the situation.
expert is going to be available at 10, y'all's expert, by Zoom.
Oh, he's just confirming. Okay.
We did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right, thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
What a long hearing. I was hoping to do the interrogation today, but I'm starving. I'm so hungry. I can't sit here and do the interrogation. But I think we'll do it tomorrow, because tomorrow, I don't think there's anything going on tomorrow. We'll just sit here, do the interrogation, and then as the judge's orders come through, we'll read them together. Oh boy, a lot happened today. I'll do a quick little recap in case you guys missed anything. Now, the audio for today was really, really bad. Usually when I edit the video, the audio is a bit better. It's a little bit more balanced, and it doesn't peak as much. So when I edit this video later today, hopefully the audio will be, the audio will be better, but I will have a lot to work with. The audio was super crusty today, man. Is that it? Is that it of the live feed? Oh, there's more. I don't know why the stream froze, but there's no more. That's it. We get the rainbow and the gray squares. Okay. Oh boy. Okay. Whew. We got a lot. I didn't expect Sarah Boone to testify today. Honestly, when Mr. Owens said that Sarah Boone was going to testify, I just thought he meant during trial that she was going to testify to it. I didn't know that he was going to actually have her go up there today and give her side of the story. But I mean, it makes sense, I guess, for the judge to make his decision. So today we addressed 3 motions, and I really thought today was going to be a short court hearing today. I thought maybe like 40 minutes tops, okay? All right, so what do we go over today? I don't have my glasses on, so this might be a little bit of a struggle. It's a little bit fuzzy. We did 3 motions today. One was a motion to suppress. One was a motion or for the rights for the hair, makeup, cosmetics, to remove restraints during trial. And then the last motion was in regards to the, I forgot already. What was it? We just talked about it. Oh, it was protective order. Okay. Let's go through each one. So today, a lot of things were filed, and we were trying to catch up with it as the court was starting. They did start late today. For the motion to suppress, the defense wants to suppress a 2-hour interrogation video. Now, this was already argued back and forth a couple weeks ago, and it seems like today the defense didn't really add any more value to their arguments. There was a lot of back and forth between him and the judge, and it was exactly the same thing that happened already in a different hearing. So the defense wants to suppress a 2-hour interrogation video. They said that the detective at the time did not read the Miranda cards fully, and so there was like 9 questions on the Miranda card, okay? She didn't read the 9th question. Well, the judge and the state is like, okay, well, if you're looking at case law for Miranda, you got to ask the 4 main questions, which is you have the right to remain silent, blah, blah, blah. You have to ask those 4 statements. Sorry, you have to say those 4 statements. And so that was done. Whether or not this was, part of policy that she had to read the 9th question on the card, that was the issue the defense was bringing up. But the judge is like, no, if you look at the case law, you don't need to say the 4 things about the Miranda. And so lots of back and forth with this one. We actually had the Detective Chelsea Koepsell. She went up there and she testified, talked about how she was on the scene. She was the detective. She asked Sarah Boone to come in, do the questioning, blah, blah, blah. And her explanation as to why she didn't ask the 9th question, why she didn't ask the last question that was on the card, it was because the card that she had at the time only had 8 things on there that she was required to read to Sarah Boone. And so James Owens was like, oh, did you just not make an effort to get the most up-to-date card? And she's like, well, I got the card in 2013 when I was hired, blah, blah, blah. And so that's about it. That's why she didn't read the number 9, because she didn't have the number 9 on the card that she had in possession at that time. So she went up there, she testified. And then we had Sarah Boone also went up there, and she also testified as well. Where's Sarah Boone part? Sarah Boone. Oh, God, there's a lot today. All right, Sarah Boone. Oh, there was a lot of spicy back and forth between, well, it wasn't super back and forth, but Mr. J, definitely threw some jabs today at Mr. Owens. I think he's starting to really lose his patience with Mr. Owens, and I'm starting to hear it a little bit in some of the things that he's saying, and he's kind of like sighing out a little bit. Let's see. Lots of sustained. I remember... See. Oh, so Sarah Boone went up there, and where the hell is the Sarah Boone part? Oh, here's the Sarah Boone part. Okay, Sarah Boone part. Sarah Boone went up there and testified, and she was talking about the mental state that she was in. She was like, I was very confused. It was very hazy. I didn't understand, the amount of people that were there, what they were doing. I was really worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation. And then I'm like thinking about the body cam footage. I'm like, I remember her being really erratic, and she was asking for, she was really thirsty. She wanted to drink something because, when you're hungover, you're probably really thirsty. You're super dehydrated. She wanted her Dr. Pepper. She wanted her cigarettes. I don't remember her saying anything about like, oh, how are my dogs? Are my dogs okay? Can I go get my dogs? Can someone come here and get my dogs? I don't remember her asking about her son or anything like that. But, maybe it was all in her head and she didn't say it out loud. But when she went up there and testified, she definitely had a different demeanor. In terms of you're trying to compare her to, the language that she uses and the letters that she writes to the judge, right? She's like, it's just very different, very confrontational, very accusatory. And even when she's going back and forth with the judge in these hearings, we got a different side of Sarah Boone. This Sarah Boone was like, oh, hi, my name is Jody Arias, and I'm here to testify, and I'm going to talk very quietly. And I was just so confused. I didn't know what was going on. Like, oh my God, I'm a victim. That was the feeling. That was kind of like the feeling that I got when she was up there. So we're getting a little bit of a preview about Sarah Boone if she were to go up there to testify for the trial. So the thing that really stood out to me with Sarah Boone, because she was trying to say that like, oh, she was tricked by detectives into asking, answering questions. She was tricked by the detectives and giving them the cell phone. I think she was trying to say that like, hey, the detective came up to me, was like, where's your phone? I told her where my phone was. It was on the kitchen counter. She grabbed the phone. She came up to me and was like, hey, put your PIN number in. And she did it. And then she said she went away. No waiver was signed before then. However, when Mr. J came up there to cross-examine her, he was like, okay, so you admit that you were impaired from alcohol, probably from the day before, right? Because you were drinking the day before. She's like, yes. And he's like, you didn't go to brunch or anything like that? And she's like, no, I didn't go to brunch or anything. He's like, okay, well, is it possible that maybe your memory could have been affected by your alcohol? Because it seems like your version of events is different than Detective Koepsell's version of events. And at that point, you could tell that she was stuck. And, Mr. James Owens tried to bail her out at that point, and it's obvious that she realized she was kind of in a trap. So definitely worth watching that part. There were some objections in the court. I remember the judge telling Mr. Owens that, okay, if you're going to make an objection, I don't want speaking objections. I want you to give me a legal objection. And then Mr. Owens like, I don't have one. He's like, okay, next. So lots of objections, lots of going back and forth. We had some good back and forth between James Owens and the judge today. The state conceded that it was an custodial interrogation. They're not saying that it wasn't. Oh, gosh, I have a lot. So in regards to the motion to suppress, the judge said that even though tomorrow is a court holiday, he's going to be working. He'll have his ruling tomorrow, a written ruling, so we can read that tomorrow when we watch the interrogation. And then... okay, next was hair, makeup, restraints. Oh, taxi. Thank you so much for the Sunny 249. Thank you so much for your support. I appreciate it. Thank you, thank you. Is she going to sack Mr. She can't be sacking Mr. Owens. Nah, she got to keep him. It's the best that she's got right now. Hair and makeup restraints. Okay, so the restraints thing. The state had no issue with Sarah Boone being hands-free. They already agreed to her being hands-free. However, she's going to have leg restraints, right? I think they're going to give her probably like leg shackles. And so... they were fine with that. Mr. Owens thought it was unnecessary to have the leg restraints, and he kept saying, I feel. No case law, really. In terms of hair and makeup, I think they were trying to figure out how to put makeup on Sarah Boone. They were like, oh, we can just do the makeup here. We can just do the makeup in the back. And the judge is like, no, you can't do that. So they wanted to have the makeup done in the courtroom. But, the judge was like, okay, well, you're going to have a really small window where you can apply the makeup, because I think Mr. Owens pitched having, he called it the paralegals. They're not paralegals, but he pitched having the paralegal, because they're females, to do the makeup for Sarah Boone. And the judge was like, you're going to have a very short window of time. Like whenever the court starts, at 9 a.m., we're just going to start. Okay. But later on, the jailhouse and the sheriff's office was like, oh, no, we don't want her having makeup on, because that could be like contraband, like her having makeup on her face and they have to bring her back in. It could be contraband. We don't know what the ingredients are made of, blah, blah, blah. So seems like a no to that one. And for the last one, the protective order. Okay, so the state said that there were, they got a witness list of all the people that the defense was planning on subpoenaing for the trial. to have to testify. And so some of the people who were on there were listed. They worked for the, where is it? Some of them were prosecutors. Some of them worked for like the victim advocate's office. And Mr. J was arguing that like, oh, like we can't be, you know, like we don't need to basically expose their work product. That's something that's protected, and you know you just can't ask for it. However, if the defense really wants to, maybe they can put in a public records request. Yes, put in a public records request, and he can do it through that. Mr. Owens was like, oh, we're not trying to ask, because the reason why they want this in is because they're trying to show that George was arrested 3 to 4 times and that 3 of those times it was dismissed. However, he's trying to argue and say that like it was dismissed by, you know, like the state attorneys. It wasn't dismissed by Sarah Boone. She didn't say that she wanted to have it dismissed, I guess. I think that's what he was trying to say. And he's not asking for like, you know, why they dismissed the case. He just wants to tell the jury that it was dismissed because it was chosen by not Sarah Boone, I guess is what he's trying to say. And so the judge was like, okay, well, I'll have a written order for that tomorrow as well. So today, Sarah Boone met with the state's battered spouse expert. They met with her today, I think for about 2 hours. I think I heard, was it either 10 to 2 or 12 to 2? They're going to have the deposition done tomorrow, but the state says, hey, like based on what we heard so far with Sarah Boone meeting with our expert, we're still going to file a motion in limine about, you know, to exclude the battered spouse defense. So can you imagine if Mr. Owens, if Sarah Boone, if they're not allowed to introduce the battered spouse defense, what are they going to do? What are they going to scramble for next week? Because, you know, Dr. Julie Harper, when she's testifying, you know, sometimes next week or 2 weeks from now, she's going to rely on the battered spouse defense, but they don't have that to rely on. What are they going to work with? I don't know. It's going to be a hot mess. Was there anything else? Monday, they're going to address the motion. So we'll be here on Monday. And then Monday is also when jury selection is going to happen. And that's what I got. That's what I got today. If I missed anything, just feel free to just write it, because I was just trying to quickly skim through all of my giant notes that I have today. Any news on the Adelson case? I have not heard anything about the Adelson case. The only thing that I heard was possibly, I don't know, it wasn't the grapevine. I don't think it's confirmed or anything, but maybe a plea deal. I don't know. We'll see what happens with that one. But so far, I haven't heard anything about the Adelson case. I think I heard that if the Adelson case for Donna Adelson, if that case is going to be tried, most likely it'll be in 2025. That's all I remember reading about it. It wouldn't be this year, because I was like, oh, maybe, you know, they'll schedule it for November or December. But I heard if it does happen, it'll probably be like early of 2025. But yeah, I wonder how Donna feels about her son Charlie now. She can make a bomb out of a lipstick. She's a straight A student in high school after all. So yeah, no fuss for Donna. So tomorrow, we'll watch the interrogation video just as a refresher. Why not? And then as we're watching the interrogation video, we'll just keep refreshing the Orange County Clerk of Court website to see if, you know, what the judge has decided on the 2 other motions. So the motion to suppress, and then also the protective order. All right. All right, y'all. I was trying to go through that really quickly because I'm hungry. I need to go eat lunch. But I hope you guys have thanks for joining us for today. We're definitely going to be streaming the trial. I am going to stream the trial live. I think we'll start when the court starts. I was a little hesitant because usually I like to speed it up a little bit, especially at the pace and the speed that some people speak at. I feel like it's better to listen to them at 1.25 or 1.5 speed. But I think it'll work out fine, because I think we'll start the trial when the trial starts, which is going to be 6 a.m. my time, 9 a.m. If you're in the Eastern time zone. And I mean, usually we'll pause and talk, and then we can speed up a little bit here and there and stuff like that. So no, I haven't watched it. I haven't watched it yet. No, I haven't, because I was planning on doing all this with you guys. And then, you know, sometimes the hearings go on for really long, and then I get really hungry, and I'm like, okay, well, I'm going to end my stream right now because I'm starving. Hey, Fat Yoshi. Yeah, Books with Sarah, thank you. No, thank you. Yeah, that's a Discord right there. Guys, if you guys haven't, feel free to join the Discord. Have your notifications on. You can have it on. I usually do the notification on Discord when I'm about to go live. And then on YouTube, have your notifications on as well. And then also for my channel, I think what I'm going to do is I'm just going to separate out the So for this channel, I'm just going to do all the true crime stuff because a long time ago, this channel was a bunch of other stuff. And then I started doing the true crime stuff. And then I would do a mix of true crime stuff and all the other stuff. But I think now, I think I'm just going to just keep it all true crime stuff and just have it separated because I think I'll like that better. So for the vlogs and all that stuff, I'm just going to keep it on like a different channel for myself. And then if you guys want to check it out, feel free. But I think for this channel, we're just going to do all true crime stuff. Sometimes it feels weird to mix the true crime stuff with like my vlogs. And I'm like, I feel like it doesn't belong here anymore. You know, before we used to have a good mix of like everything else, but I think it's better just to do all the true crime stuff on here. And then I'll just have a separate channel for like all the other stuff that I feel like uploading.